Well, I want to talk a little bit about risk assessments. So this is, in my view, this is where things get real for companies. And part of this is, which I really like, is about uh, prevention. Some prevention and awareness with a company about where they stand and where they need to be. So it's kind of a temperature taking type of thing. But give me your thoughts about risk assessments. I feel like people um, I don't know, maybe risk assessments may seem in the US more controversial than they are in other places because we know, especially like in Europe, a lot of their laws and regulations have for years called for risk assessments. And so the risk assessment requirements that we're seeing come up in the US may be new for some companies, but I want your thoughts.
Yeah, well, again, this was built into the statute that was passed by the voters that we had to write regulations, specific to risk assessments. And what the law said and what the regulations say that businesses must perform a documented risk assessment whenever their processing of personal information poses a significant risk to consumers' privacy. Now, the way that we define that is common triggers include selling and sharing of data, processing the sensitive personal information at scale, using automated decision making for significant decisions. So those are some of the examples. And so what the regulations require, and this actually, again, for your listeners, they should know that risk assessments must, if you're a business defined under California law and it meets the requirements as I just set forth about the significant risk, that these assessments must be conducted before initiating new high risk processing beginning January 1st, 2026. So the clock has already started ticking. For those systems that predate the regulations but continue after January 1st, the assessments must be completed by December 31st, 2027. And so the assessments themselves must be in writing, must be retained for 5 years, and must be reviewed and updated every 3 years. And then the last requirement is that businesses that meet the definition again of business and then have high risk, significant risk processing activities, as I spelled out, that they need to complete an attestation report and submit that to Cal Privacy by April 1st, 2028 for the assessments conducted in 26 and 27. So is going to be paperwork that will need to be submitted in 2 years and 2 months, roughly. But the assessments should begin now. The way that we wrote these is that a lot of the assessment work that you may be doing for GDPR or for Colorado's is applicable as well. We didn't want people reinventing the wheel, so probably a lot of the requirements that you have for the assessments that you do in Europe or to meet Colorado's requirements are applicable here. Obviously, you need to, I can't speak to every assessment because I don't know what's going on internally. Now, we will, starting this year, start working on documenting the process and the form in the submission. So we will provide businesses plenty of heads up about how you go about submitting these to the agencies. I can announce on your podcast that we have hired a chief privacy auditor, and we have formed just a day or two ago, and we have formed an audits division. Now, that was in the press release, but what I'm telling you, Debbie, is that, and your listeners, is that the audits division will be the organization within Cal Privacy that will define and document the whole attestation process and be the entity within Cal Privacy that process these as well. And they will also be the entity that is responsible for the cybersecurity certifications as well. So we will document the process because there's a requirement for both risk assessment attestations as well as cybersecurity certifications to be submitted to the agency based on the definitions I've set forth.